the jurisdictions, primarily the pecuniary jurisdiction, subject matter jurisdiction, and territorial jurisdiction. Last but not the least, we'll discuss about the objections, what all objections we can raise regarding the jurisdiction under the CRPC. Followed by this session will take some of the doubts from the attendees in the end of the session, where you can write your questions in a Q&A tab. So today as a guest speaker, we have with us Mr. Mahendar Bangeja. He is an independent litigator. So I welcome you, sir, and it's a pleasure to have you on a webinar again. And without any further ado, now I'll request you to please take over this webinar.
Thank you, Anu, for such a kind introduction. I'll straight away begin. Yep, I'll share my screen.
Right. You can share your screen now.
Okay. Okay. So first, in today's session, I'll be dealing with the overview of CPC, and then I'll briefly explain the procedure of civil suits, procedure involved in civil suits. Then we'll understand section 9, which is also known as the gateway of CPC. Whenever you initiate any proceedings or a suit, the power given to the court is under section 9 to try the said suit. And then we'll understand the subject matter jurisdiction while we are studying section 9. And then we'll go towards the pecuniary jurisdiction. There we'll read section 3, 6 and 15 conjointly, and then we'll understand territorial jurisdiction. If at all, if it's not too heavy, then we'll go towards objections. But I suppose that I should take this in any another session, because it already a lot will be on the plate. But anyways, we'll try to complete everything. Now, to start, first I'll proceed with the overview. But before starting, I want you guys, whenever I read a particular section, I want you guys to read that section also. Of course, you guys have to mute your mics. But you have to read along with me, otherwise you won't understand the provisions thoroughly. So I'll proceed with the overview. Now, Civil Procedure Code. Now the question is why it is known as code and not act. Now we need to understand the difference between an act and a code. A code is basically compilation of all the existing laws. मतलब पहले भी CPC के पहले भी already existing civil procedure से related laws थे. वो था 1858 Act, 1877 Act and 1882 Act. तो 1908 Act ने क्या किया, इन सबको compile किया, and that is the reason it is known as a code and not an act. Act क्या है? Act is creation of a new law out of the legislative wisdom of the legislature. A code is a compilation. For example, IPC के पहले भी obviously penal provisions होते होंगे. IPC merely compiles all the penal provision. CRPC के पहले भी criminal procedure होता होगा. CRPC compiles all the criminal procedure. So that is the reason the purpose of the act is to consolidate and amend the laws relating to procedure of civil judicature. Now, this act is purely procedural. As in, there is a difference between substantive law and a procedural law. Substantive law creates rights and liabilities, while a procedural law provides for a procedure to enforce those rights. Now, CPC provides for a procedure to enforce those rights, but certain aspects of CPC are substantive in nature. For example, mesne profit, section 212, mesne profits, the concept of restitution. These are substantive in nature. Now, CPC as a whole is divided into two parts. One part deals with all the sections, and the other part is orders. 158 sections hai or order 51 hai. Now, people generally ask me what is the difference between these both. See, sections are the substantive provisions, जो main provisions हैं. Sections आपको बताते हैं कि क्या होना है. For example, section 33 आपको बताता है कि there has to be a decree after the judgment. And order 20 provides कि decree कैसी होनी चाहिए. It has to be signed, it has to be within so and so date. So it provides for the procedure. For example, section 26 says that a suit is instituted by a plaint, and order 4 provides that a plaint has to be in duplicate form. So basically that is the difference between these parts, order and section. Sections are more substantive provisions. Orders, they elaborate the procedure. Now let us understand the procedure of entire civil in a civil suit, procedure involved in a civil suit. The first thing that you do in a civil suit is file a plaint. So the plaint is presented before the filing counter, and it is presented in duplicate form. Matlab 2 copies. 2 copies you will have to present. Then what happens? The suit is numbered by the reader. He will examine the valuation, and he will see if there are any office objections. Agar office objections nahi hai, he will number the suit. If there are office objections, he will intimate you. He will tell you to correct these objections within 7 days. Now this period of 7 days differs from state to state, and it is conventional, and it also differs, in some cases it also differs from court to court also. But in most cases it is 7 days. Within 7 days you'll have to clear the office objections. Now office objections कैसे हो सकते हैं कि translated copy properly translated नहीं है, the photocopy is not appearing to be in a proper format, the format of the plaint is not correct, and the signatures of the plaintiff are missing, the verification is missing. So all those objections are raised by the filing counter. Then what happens in court? In court, the court will either reject or accept the plaint. Now, the grounds for rejections of the plaint are provided in Order 7, Rule 11. Now, पहला ground है कि now plaints can be rejected in these cases. First is if it does not disclose the cause of action. अगर plaint undervalued है, और अगर not duly stamped hai, and if the suit is barred by any law, and this is barred by any law, and if the plaint is not filed in duplicate, agar duplicate mein filed nahi hai, then also the plaint will be rejected. And if you haven't paid the process fee, on these grounds the plaint may be rejected. Now if the plaint is accepted, then what happens? Then the court orders issue of summons. The court will order issue of summons. Court बोलेगा summon issue कीजिए, and within 7 days of the said order, जब ये order किया गया है, within 7 days you will have to pay process fee. If the plaintiff fails to pay the process fee, then the suit will be dismissed, or the plaint can be rejected also, जैसे पहले बताया था मैंने. Then the summon is served on the defendant, and the defendant appears. After defendant appearing, he'll have to file his written statement within 30 days. Now ये 30 days का period extend हो सकता है up to 90 days if he provides proper reasons for his delay. फिर उसके बाद होती है फर्स्ट हियरिंग में पहले कोर्ट एग्जामिन करता है दोनों प्लीडिंग्स के, प्लेंटिफ का ये प्लेंट एंड डिफेंडेंट का WS, एंड ही विल एग्जामिन बोथ द पार्टीज एंड एडमिशंस एंड डिनायल्स होंगे. On the basis of this first hearing, the court will come to a conclusion whether there are any terms of settlement. Terms of settlement हैं या ये केस में. If there are terms of settlement, then the court may refer it to ADR, alternate dispute resolution. So ADR केस 4 methods बताए हैं CPC में. One is arbitration, second is conciliation, third is judicial settlement, and fourth is mediation, which is done by लोक अदालत्स. इन दोनों में, arbitration and conciliation में, you will need the consent of the parties before the filing of the suit, obviously. And in that case, the court, in other cases, the court will see whether there are terms of settlement. For instance, there are no terms of settlement. Assuming there are no terms of settlement, then the court will settle the issues. Now, the court settles issues on only on the facts on which the parties are at variance. For example, there is a suit between me and Anu. Anu files a suit against me, and for breach of contract. Anu files a suit against me for breach of contract, and Anu says that yes, Mahendar was ready and willing to perform his part, and even I say that I was ready and willing to perform my part. So we are not at variance. So ये बात का issue नहीं बनेगा. But if Anu says that I was not ready and willing to perform my part, and I say I was ready and willing to perform my part, then we are at variance, and issue banega whether Mahendar was ready and willing to perform his part of the contract. उसके बाद issues के बाद trial start होता है. Trial में plaintiff witness, defendant witness, plaintiff produces his documents, and even defendant produces his documents as evidence, and ultimately on the basis of evidences the judgment is pronounced. The story does not end there. CPC gets more interesting after this. After the judgment is ordered, you'll have to go for execution. You'll have to execute the decree itself. Just because आपके favor में decree है does not mean you have got the amount itself. You'll have to execute it, and you can file an appeal also if you are aggrieved by the decision. And अगर appeal में order reverse हो जाता है, then you can go for restitution. Now this is an interesting concept. For example, Anu sues me for possession of an immovable property, and the court decrees in her favor, और मैं उसे property दे देता हूँ, property का possession दे देता हूँ. But then I go in appeal and I win the case, and the judgment of the trial court is reversed, और appeal में मेरे favor में decision आ जाता है. Then I'll have to file restitution to claim the property which I had given to Anu in compliance of the decree, and I'll also get the mesne profits for the time Anu was in possession. Clear? Any doubts so far?
No one.
No one?
Anybody has doubt, they can write in a chat box. Yes, no issues as of now.
No issues? Okay. Now let's start with section 9, which is the gateway of CPC. Basically, CPC begins at section 9, I would say, because it acknowledges the power of civil court to try cases of civil nature. Now, I want you guys to read along with me. This is the bare provision, and it goes like this. The court shall, now it's a mandatory, the court shall, subject to the provisions herein contained, have jurisdiction to try all suits of civil nature, excepting the suit of which their cognizance is either expressly or impliedly barred. So basically, this provision says that court has jurisdiction to try suits of all civil nature, but सिर्फ दो restrictions हैं. One restriction is within CPC itself. That is the reason they have used this word, subject to the provision herein contained. And the second restriction is outside CPC, either expressly or impliedly barred. So the question is, what are restrictions within CPC? So restrictions such as res judicata, it is within CPC. Section 11 provides for the same. Restrictions such as Order 9, Rule 9, these are within CPC. Restrictions such as Order 2, Rule 2, these are within CPC. ये CPC के अंदर ही restrictions हैं. And कुछ बाहर restrictions हैं which any other act provides. So वो चीजें civil court नहीं try कर सकता. Now I will not be dealing with the meaning of civil nature in this session, because we are basically dealing with the jurisdiction itself. So I will be only dealing with the restrictions within CPC and outside CPC, and I'll explain you section 11 thoroughly. See, so the use of words subject to the provision herein contained creates a bar within CPC, and expressly and impliedly barred creates a bar outside CPC. Okay. Now, the section 9 was discussed at length in Abdul Ghaffur versus State of Uttarakhand, wherein it was held that every court has inherent jurisdiction to try cases of civil nature. Now, as per jurisdiction, if the court has inherent jurisdiction, then every individual will have an inherent right to file the suit of civil nature. But both these, even the right and the inherent jurisdiction, are subject to the restrictions within CPC and outside CPC. The said purpose was elaborated in Gangabai versus Vijay Kumar, wherein it was said that Section 9 makes the maxim ubi jus ibi remedium, which is where there is right, there is a remedy, effective. And it provides for a mechanism to claim a relief. And it was also said that the jurisdiction of civil court is plenary. Plenary means wide. And you cannot impute any unnecessary restrictions, but only restrictions which are expressly and impliedly provided in CPC or outside CPC. Only these restrictions. Now, there was this one interesting point which was held by this court, by the Supreme Court. It was the presumption of jurisdiction. It said that whenever a suit is filed before the civil court, it will be presumed that that civil court has the jurisdiction to try it. And the person who raises the objection regarding the lack of jurisdiction will have the burden of proving it. So we will presume that the court has jurisdiction, and the opposite party or the person objecting will have to rebut it. Clear? Now, what if, the question was, what if the defect of jurisdiction is manifest? For example, a subject matter is situated in Mumbai and you are filing a suit in Chennai, then what? The court held that if the subject matter, if the defect of jurisdiction is manifest, then the court can return the plaint. It can return the plaint and the party can file it before the appropriate court. The court can return the plaint under Order 7, Rule 10. Clear so far? Okay. Now let us understand what are express and implied powers. See, if there is a special law for a special subject matter, and for that subject matter a special court is created, and it is expressly provided in the act that the civil court is barred to try such cases, then it is a express bar. समझा? स्पेशल लॉ है, स्पेशल सब्जेक्ट मैटर है, और स्पेशल सब्जेक्ट मैटर के लिए स्पेशल कोड बनाया है, and it is also stated in the statute itself that the civil court will have no jurisdiction in this case, then it is an express bar. Expressly बता दिया ना. But there may be a situation wherein special courts तो created हैं, but जो civil court का jurisdiction है, that is not barred. In that case, the court will examine the purpose of law. It will examine the other provisions of law. It will examine the terms of reference of that court, and it will also examine the intention of the legislature, and then it will infer the implied bar. अगर purpose of law ये है कि उन्हें civil court को jurisdiction देना ही नहीं था, then it will be an implied bar. If other express provisions are in connivance with the fact that civil court is not supposed to have jurisdiction, then again implied bar. If the intention of legislature is such that the civil court are not supposed to have jurisdiction, then again implied bar. Now there are few examples of express bar. Now this is what I call subject matter jurisdiction. This express and implied bar, SM jurisdiction. Now these courts will have jurisdiction only of a particular subject matter. For example, an income tax tribunal will have a subject matter to try only income tax related cases. Probate court will have jurisdiction to try only probate cases. NCLT only company law related matters. Labor court only labor law related matter. Family court family matters. CAT administrative matter. Clear so far?
Yes.
Okay. Wait a sec. Okay. I can't see my chat. Okay. Now, this is one interesting case, Dullabai versus State of MP, and the judgment was delivered by Chief Justice M. Hidayatullah back then in 68. Now the case says that despite of express and implied bar, civil courts will have jurisdiction in following cases. मतलब express और implied bar के रहते हुए भी civil court को इन cases में jurisdiction मिल जाएगी. First is if the remedies provided in the statute are inadequate, then civil court will have jurisdiction. If the statute itself is unconstitutional, then also civil court will have jurisdiction. If the statute is constitutional but tribunal has violated the provisions of statute 1 and it has violated the principle of natural justice 2, in these cases the civil court will have jurisdiction despite of express and implied bar. Clear?
Yes.
Now we are moving towards the next session. If at all you guys have any doubt relating to section 9, it is the right time to clear. Other than doubt relating to civil nature, because this is not the session I will be covering the concept of civil nature. Should I proceed?
Yes. If anybody has doubt, they can write in a chat box. Okay. As of now, there is no doubt, so we can move further.
Okay. Okay. Now, see, basically there are three. CPC basically carves three kinds of jurisdiction. The first is territorial, which has been provided in section 16 to 20. The next is pecuniary. Now, we can infer pecuniary jurisdiction on conjoint reading of section 3, section 6 and section 15. Matlab, don't get scared, we'll be getting there. Aram se. And the last is subject matter jurisdiction that we have already covered under section 9. Okay. Now the question is what will happen if a court has no territorial or pecuniary or subject matter jurisdiction and it still hears the case and passes a decree? So the answer to it is, if the court has no territorial jurisdiction and no pecuniary jurisdiction, then the decree will be illegal or irregular. But if the court has no subject matter jurisdiction and it still passes the decree, then the decree will be void. Now, an illegal decree you can set aside in appeal, but a void decree you can set aside by filing a separate suit also. Clear? I see some. Wait.
Screen is
Anu,
not
can you see the
visible.
chat?
Yeah, actually it is. Yeah, they are saying screen is not visible. I can see the screen.
Okay,
if anybody else cannot able to see the screen, please write it down because I am able to. Okay, it is visible, I guess.
It is visible. I'll proceed.
Yeah, screen is visible. Yeah.
Okay. Now, first we'll start with pecuniary jurisdiction. We'll understand section 3, 5. Section 3, 6 and 15. Section 3, 6 and 15. And then we'll move on towards territorial jurisdiction. Okay. Now, first let us understand section 3. Section 3 basically provides for the hierarchy of the court. कि court की hierarchy क्या होगी? And I'll read. I want you guys to read along with me. For the purpose of this court, the district court is subordinate to high court. And every civil court of a grade inferior to that of a district court and every court of small causes court is subordinate to high court and district court. So what this section is trying to say, that see, district court is subordinate to high court and any court inferior to district court, which may be civil judge senior division, civil judge junior division, is not only subordinate to district court, but obviously he will be subordinate to high court also. Clear? And this is basically the hierarchy of the courts. Now section 6 lays down an interesting point. Section 6 says that no court can try a subject matter which exceeds its pecuniary limit. Now the question is, what are these pecuniary limits and where are these pecuniary limits provided? These pecuniary limits are provided in Courts Act of every state, and they differ from state to state. And if any court passes a decree or tries a subject matter above these pecuniary limits, then the decree will be irregular. Now I have got a particular data of all the states and their pecuniary limits. I will show you, not all 28, but most prominent states. And I'm sorry I've ignored South because I couldn't research much, but I'll be covering it later on. In Madhya Pradesh, the civil judge second division has a pecuniary limit up to 5 lakhs. So 5 lakh के ऊपर he cannot try. और सिविल जज फर्स्ट क्लास के पास पिक्यूनरी ज्यूरिसडिक्शन है 5 lakhs to 1 crore, और डिस्ट्रिक्ट कोर्ट के पास पिक्यूनरी ज्यूरिसडिक्शन है अबव 1 crore, 1 crore के ऊपर. एंड हाई कोर्ट के पास कोई ओरिजिनल ज्यूरिसडिक्शन नहीं है. मतलब इन मध्य प्रदेश यू कैन नॉट डायरेक्टली फाइल अ सूट बिफोर द हाई कोर्ट, बट ओनली एन अपील विल लाई. क्लियर? बिकॉज देयर इज अ रीजन टू इट, बिकॉज डिस्ट्रिक्ट कोर्ट के पास 1 crore के ऊपर की सारी ज्यूरिसडिक्शन है ना. So जो भी 1 crore के ऊपर के मैटर्स हैं, that will be heard by the district court. Now same is the case with Chhattisgarh. Less than 5 lakhs, second class. 5 to 10 lakhs, first class. And district court above 10 lakhs. And again, even here, the high court does not have original jurisdiction. They only have appellate jurisdiction. क्योंकि उन्होंने district court को इतनी power दे दी है. All matters above 1 lakh will be tried by district court. Now in Maharashtra, the thing is that the pecuniary limit differs from regions to regions, but broadly this is the pecuniary limit in most parts of Maharashtra. The first is that subordinate district court के पास jurisdiction रहेगी 10 lakhs तक, city civil के पास up to 1 crore तक, and above 1 crore will be by high court. Now here you have original jurisdiction before the high court. तो महाराष्ट्र में ओरिजिनल जुरिसडिक्शन है हाई कोर्ट की, एंड यू कैन फाइल अ सूट बिफोर द हाई कोर्ट इफ योर सब्जेक्ट मैटर इज मोर देन 1 CR. एंड सेम इज द केस विद दिल्ली. स्मॉल कॉजेस कोर्ट 5,000 तक, सीनियर सिविल जज 5,000 to 3 lakhs तक, और डिस्ट्रिक्ट जज 3 lakhs to 2 crores. एंड इफ इट इज मोर देन 2 crore, देन हाई कोर्ट मोर देन 2 CR. And UP में, now the funny thing in UP is that if civil judge junior division की pecuniary limit है less than 5 lakhs, and senior division की unlimited है, and district judge की original jurisdiction नहीं है, and high court की भी original jurisdiction नहीं है. Same is the thing with Bihar. Clear? And this is when we can understand. Now this is where we will understand section 15. Now section 15 बोलता है कि every suit shall be instituted in the court of lowest grade. इसका मतलब क्या हुआ? इसका मतलब ये हुआ कि see, for example in this case, in case of Maharashtra, suppose मेरा subject matter है 6 lakhs का, so obviously it makes sense. 6 lakh का subject matter है, even city civil has the jurisdiction, क्योंकि 10 crore तक तो वो ट्राई कर ही, 1 crore तक तो वो ट्राई कर ही सकता है ना. तो 6 lakh को तो ट्राई कर ही सकता है. He is not incompetent. But the problem is section 15 mandates me to file the suit before the court of lowest grade. तो इस केस में lowest grade is subordinate district court. इसलिए I'll have to file before the lowest grade. Clear? So this was your pecuniary jurisdiction. Any doubts?
Yes, we have one doubt from Advocate Sunil Joshi, and he's asking if I have to file civil suit, where it goes. Like a very basic question.
If you file a civil,
if I wanted to file a civil suit,
depends upon your subject matter. Depends upon your subject matter. Depends upon your pecuniary limit of the civil suit, and subject matter and pecuniary limit.
Right. Another question we are getting from Shruti Singh, and she's asking, do the pecuniary limits gets amended? You know,
Yeah. They do get amended from time to time. In fact, in Chhattisgarh, the pecuniary limit was amended in 2010 itself, which is recently. For
right.
CPC, it is recent.
Hmm.
You may call it 10 years, but for CPC, it is recent.
Uh, yes, understood. Another question is from Kajal, and she's asking from where we can find these sources of pecuniary limits. If
Courts
you
Act.
can confirm.
Courts Act of each. If you click on the High Court site of any court, of any state, for example, High Court of for Chhattisgarh, High Court of Bilaspur, for Bombay, High Court of Bombay, you will find Courts Act there. So you can click on that, you will find. Okay, I'll proceed. I'll proceed with territorial jurisdiction.
Right.
Any other questions?
Uh, if you can please repeat
Oh,
the pecuniary limits
okay.
and daily.
Sorry.
Daily.
It's not very difficult. Delhi is very easy. See, 5,000 small causes, senior civil judge and CG 5,000 to 3 lakhs, and DJ 3 lakhs to 2 crores. Above 2 crores, High Court. So this is the difference between Bombay and Delhi is that in Bombay above 1 crore High Court, and in Delhi above 2 crores High Court. So in both the cases, High Court has the original, what we call OOCJ, original ordinary civil jurisdiction.
Okay.
Clear? I'll
Yes.
proceed.
Yes.
Okay. Now let us move on to territorial jurisdiction. Oh, wait. Yeah, territorial jurisdiction. Territorial jurisdiction is basically divided into 3 parts. The first part says that if it is a case of immovable property, then suit will be filed where the property, immovable property, is situated. Clear? The second part is in the cases of tort and movable property. The suit will be filed where the tort is committed and where the defendant is voluntarily residing, or he's personally working for gain or carrying on the business. And in other matters, which is residuary, we will read. This is residuary. जिसका कोई नहीं उसका section 20. ठीक है. Now I'll read section 20 and I want you guys to read along with me. And as I read it, subject to the limitation aforesaid. Now, what are these limitations? I want you guys to answer. Subject to the limitation aforesaid. Now, what are these limitations? Where is the chat? Where can I see the? Where can I find it? Okay. Wait.
Anybody would like to answer?
What are these limitations? It starts with the word subject to the limitation aforesaid. All the jurisdiction issue. So limitation of 16 to 19. AA says pecuniary jurisdiction, and which is correct. Which is correct. Now when they use the word limitation, they mean pecuniary. Subject to the limitation aforesaid because it was previously said, na? Subject to the limitation aforesaid, every suit shall be instituted in the court within the local limit of whose jurisdiction the defendant. Now you must not read this for a while. यहाँ तक काट रहा हूं मैं. The defendant at the time of commencement of the suit actually and voluntarily resides, carries on the business and personally works for gain. So basically section क्या कहना चाह रहा है? Section बोल रहा है कि you can file a suit where the defendant is residing, where he is carrying on the business and he is personally works for gain. तीन jurisdiction जगह बता रहा है आपको. And the fourth place is, this also I don't want you to read now. I'll be covering up this later. And fourth जगह है जहां cause of action arise हो रहा है. Clear? Now, why such a provision? Because see, plaintiff is the one who is seeking equity and justice. So he will have to file suit where defendant can be found. मतलब ऐसा नहीं है कि plaintiff अपनी जगह में suit file करेगा plaintiff is seeking equity and justice, so he will have to take efforts to procure that justice. इसलिए he can file a suit where the defendant works, or where defendant has a place of business, and where the defendant has its residence, या जहाँ पर cause of action partly arise होता है. Clear है?
Yes.
इसमें कोई doubt?
No. We have a doubt regarding section 15, which you just stated.
15.
So, yes.
1-5.
Yes. 15. Yes.
Okay.
So,
So
we
section
did
15 is the word is the lowest pertaining to only pecuniary jurisdiction. Yes, in this context, pecuniary jurisdiction. Yes, in this context, pecuniary jurisdiction.
right.
Okay. I'll proceed.
Yes.
Now, this is the question I want you guys to answer. There is a contract between Anu and Mahendar. Now, Mahendar breaches the contract. Clear? Now, Mahendar is a resident of Mumbai, but he works for gain in Pune. He has a business. Now, resident of Mumbai, works for gain in Pune. He has a business in Delhi. The contract was entered in Bangalore, and it was supposed to be performed in Chennai. Now, in which court Anu can file the suit for damages? And keep section 20 in mind. I'll make you guys read the section 20 again. The defendant, cut this part, at the time of commencement of the suit, actually and voluntary resides, carries on the business, or personally works for gain. The cause of action, and also where the cause of action wholly or partly arises. अब बताओ. Chats. Well.
Yes. Vishalya Jyoti has said anyone, like she wanted to say anywhere.
Anywhere where Anu resides, works, or see, Sushil Shankar, Anu resides. Anu is the plaintiff in this case, because Anu is filing the case.
Kajal is saying Pune, Bangalore, and Delhi. Kinjal is saying Pune, Delhi, Bangalore, same. Ashrishar, Mumbai. Ayush is saying Pune.
Okay. Now
Vishal
see.
is saying yeah, any among Mumbai, Delhi, or Pune.
Okay. Now see. All the places will have jurisdiction, and because I was working in Pune for gain, works for gain. Okay. I had a business in, wait, what was I doing in Delhi? I had a business in Delhi, and I was residing in Mumbai. तो ये तो section 20 clause 1 में ही आ गए सारे. Sorry, 20 clause A में ही आ गए. Bangalore में we entered into a contract, so cause of action was created there, and it was supposed to be performed in Chennai, so cause of action was partly created in Chennai. So these are all places of juridical choices. Now Anu has a choice to file a suit against me in any of these cases, in any of these places. Clear? Did you guys understand? Because it will get trickier, a little trickier, but it will get more beautiful, I would say.
Yes.
See, place of contract. See, in this case, okay. In this case, because we entered into a contract in Bangalore, and the contract was to be performed in Chennai, so both the places will have jurisdiction because the cause of action was created in both the places. Now, if you read section 20, again, section 20 का C clause पढ़िए आप. C clause says that the cause of action wholly or partly arises. That is the reason I told you that these 4 places will have jurisdiction. Is it clear?
Yes.
So one, where defendant actually and voluntary resides. Second, where carries on the business, and the fourth is where the third is personally works for gain, and fourth is cause of action. Now, what if there are more than one defendants? Now the question arises. Now see, now जो पहले कट किया था वो अब पढ़ते हैं. And this is something we had erased, na? Wait, I'll erase it. Now let's read this part. Each of the defendant, where there are more than one, at the time of commencement of the suit, actually a voluntary resides or carries on the business. Okay. Now it uses the word each of the defendant. तो इसका मतलब क्या हुआ? This means that all the defendant have to be found in a common place. For example, suppose I was to sue Pranjal, Shivsang and Hassan. So for this clause to be applicable, they all have to be found in same place. Suppose I was to sue Pranjal, Shivsang and Hassan in Mumbai. So I want Pranjal to work in Mumbai, or Shivsang to reside in Mumbai, or Hassan to have a business in Mumbai. And now since all of these guys are found in Mumbai, so this clause will be applicable and I can sue them. So all have to be found in one common place. That is the reason they have used the word each of defendant. Okay. Now second clause uses the word any of defendant. Now what does this mean? This is exactly opposite. This means that all the defendants are not found at one place. For example, in this case, Pranjal was working in Mumbai, Shivsang was residing in Patna, Hassan was having a business in Raigad, but I decide to file a suit in Mumbai. Then in that case, section 2 clause B will apply, and I will be required to take consent from the non-residents. Or I will have to take the leave of the court. Then only I can file a suit in Mumbai. Is it clear?
Yeah, leave of the court and the consent from
the non-resident. Or. It's not and, it's or. It's or, huh? It's not and. If I have the leave of the court, then I need not take the consent of the defendant who are non-resident. If I have the consent of the non-resident, I need not take the leave of the court. It's or.
We have one question.
Wait.
What is the leave of the court?
Leave of the court is the permission of the court. Clear?
Right.
Should I proceed?
Yes.
Wait, there are...
Okay, yeah, Jagannath is asking, leave of the court, as you said, is the permission, right? So means we have to take court permission from which court?
From Mumbai. The court where you are filing the suit, not the court where these guys are residing. The court where you are filing the suit, Jagannath. Is it clear?
Right.
Okay, I'll proceed. Now the main question that arises oftenly is, see, we know it's easier to ascertain the place of business for an individual. Okay, आपको पता है ये बंदा यहाँ काम कर रहा है, तो आपको पता है कि this is the place of business for him. But what will be the place of business in the cases of a corporation? So explanation for section 20 says that if the corporation has only sole or principal office in India, सिर्फ एक ही ऑफिस है, sole office है, so वो sole or principal office will be the place of business. But if corporation has branches, then also that sole office will be the place of business. But if corporation has branches, और उस branches में से एक branch में cause of action arise हुआ है इस suit का, so that branch office will be place of business. Now this is where it gets trickier. Now this was held in Patel Roadways versus Prasad Trading, wherein it was held that this explanation is divided into three parts, not two, three. Three parts. It was held that if a corporation has only a sole office, एक ही office है, so place of business होगा where the sole office is situated, obviously. If the corporation has an head office and a branch office, प्लेस ऑफ बिजनेस फिर से हेड ऑफिस ही होगा. If the corporation has an head office and a branch office and the cause of action arises at the branch office, तो place of business होगा branch office. This is the only case when place of business will be the branch office. Clear? I'll be taking up this example later. क्या हुआ था? Something happened?
No, nothing happened. It's clear.
It's clear?
Yes.
Wait, any doubts?
No, as of now, there's no doubts.
Now let us understand what is exclusive jurisdiction clause. Now क्या होता है कि whenever you enter into a contract, for the sake of safety, certain the parties, they agree to abide by a jurisdiction of only a particular court. So that is the reason they use the words subject to the jurisdiction of Mumbai court only. So now the question is whether these clauses are void. The answer to that is कि अगर दो कोर्ट्स के पास jurisdiction है, फॉर एग्जाम्पल मुंबई कोर्ट के पास jurisdiction है एंड दिल्ली कोर्ट के पास भी jurisdiction है, आपने एक कोर्ट का jurisdiction exclude कर दिया, then it is permissible. Then it is not void, it is valid because you are not absolutely restraining a person. So section 28 Indian Contract Act का है जो बोलता है कि every contract is void if it restrains legal proceedings. वो apply नहीं होगा because this will not be an absolute restraint. Clear? But things get trickier. Now if Mumbai court and Delhi court have jurisdiction, पर आप मद्रास कोर्ट को jurisdiction confer कर रहे हो एक contract के through, this agreement or this clause is void because you are conferring a jurisdiction on a court which does not have jurisdiction. Such a contract is not permissible and it will be void under section 23 and 28. Now, for this, I will explain Patel Roadways and Prasad Trading. इसमें क्या हुआ था कि जो plaintiff है, plaintiff is Prasad Trading Company. They gave a consignment of 850 kilograms of cardamom to the defendant, which is Patel Roadways. इसमें ट्रांसपोर्ट का काम था, उन्होंने उनको दे दिया कंसाइनमेंट. और ये कंसाइनमेंट कहाँ दिया था? ये दिया था उनकी सबऑर्डिनेट ऑफिस में. ना प्लेस इज इंपॉर्टेंट. कहाँ दिया था कंसाइनमेंट? ये उनकी सबऑर्डिनेट ऑफिस में तमिलनाडु में. एंड ये कंसाइनमेंट डिलीवर्ड करना था उन्हें दिल्ली. सो अब कॉज ऑफ एक्शन कहाँ राइज हो रहा है? कॉज ऑफ एक्शन तमिलनाडु में एंड दिल्ली में. ठीक है. एंड सिंस यहाँ पर उनकी ब्रांच ऑफिस भी है तमिलनाडु में रोडवेज की, तो प्लेस ऑफ बिजनेस भी यही होगा. ठीक है. सो नाउ व्हाट हैपेंड, नाउ गुड्स ट्रांसपोर्ट हो गए और गोडाउन में रखे उन्होंने दिल्ली में, बट गुड्स फायर से जल गए. सो इसलिए प्लेंटिफ ने सूट फाइल किया एंड दे फाइल्ड अ सूट इन पेरियाकुलम विच इज इन तमिलनाडु. यहाँ पर उन्होंने सूट फाइल किया. नाउ डिफेंडेंट आया, डिफेंडेंट ने बोला तमिलनाडु पेरियाकुलम, तमिलनाडु कोर्ट डज नॉट हैव jurisdiction because they have already entered into an exclusive jurisdiction clause which says that their dispute will be subject to jurisdiction in Mumbai only. They have entered into a jurisdiction clause जो बोलता है कि मुंबई कोर्ट के पास ही jurisdiction रहेगा. Now court held that कि बॉस cause of action arise हुआ है दिल्ली में और तमिलनाडु में. ब्रांच ऑफिस है आपका तमिलनाडु में जहां पर कॉज ऑफ एक्शन अराइज हुआ है, तो मुंबई कोर्ट के पास कैसे जुरिस्डिक्शन आया? सो द कोर्ट सेड दैट दिस एक्सक्लूसिव जुरिस्डिक्शन क्लॉज इज वॉइड एंड तमिलनाडु कोर्ट हैज जुरिस्डिक्शन. एनी डाउट्स?
No questions as of now.
No questions? I'll proceed?
Yes.
Okay. This is what was held, and I'll read. The party cannot, by mutual agreement, confer jurisdiction upon such court which actually does not have jurisdiction. जैसे इस केस में मुंबई कोर्ट के पास jurisdiction ही नहीं थी. तमिलनाडु में cause of action arise हुआ, दिल्ली में arise हुआ है. तमिलनाडु में उनका place of business है because they have a branch office जहाँ पर cause of action arise हुआ है by the virtue of explanation. of section 20. So इसलिए ये exclusive jurisdiction clause void है under section 23 and 28 of Indian Contract Act. Clear? Now this is
yeah. Why void, not irregular?
who is this? Wait.
It is
Wait.
it is me who is asking.
Oh, you are asking. Sorry. See, there is no concept of irregular in Indian Contracts Act. It's only void or voidable.
Okay.
So either things can be voidable or void. In this case, it is void. The reason is section 28 tells you that any contract which restrains legal proceedings absolutely is void. Or section 23 says you that any contract which is against public policy and which breaches established provisions of law is void. In this case, the contract was breaching established provision of law क्योंकि वो एक ऐसी कोर्ट को jurisdiction दे रहे थे जिनके पास थी ही नहीं. So they were going against the provisions of CPC itself. So that is not permissible. That is not allowed. Now, the argument or the conversation changes a little in the cases of arbitration. Now, this is a fun case, and this is a 2017 case. It is in Indus Mobile Distribution versus Data Wind Innovation. And the judgment was pronounced by R.F. Nariman, Rohington Fali Nariman, and P.C. Ghose. Now, इसमें क्या हुआ था? जो defendant था, he was registered in Amritsar, Punjab, and he was supplying goods to Chennai from Delhi. तो डिफेंडेंट अमृतसर में तो पहला प्लेस हो गया अमृतसर, दूसरा प्लेस हो गया चेन्नई. कॉज ऑफ एक्शन कहाँ अराइज हुआ? चेन्नई. एंड फिर तीसरा प्लेस हुआ जहाँ कॉज ऑफ एक्शन अराइज हुआ न्यू दिल्ली, क्योंकि थ्रू जा रहे थे ना. सो दीज 3 कोर्ट्स हैव जुरिस्डिक्शन. पर उनका जो आर्बिट्रेशन का सीट था दैट वाज इन मुंबई फॉर सम रीजन, and the exclusive jurisdiction clause said that only Mumbai courts will have jurisdiction. Now case came before the Supreme Court. Supreme Court said that in this case Mumbai court will only have jurisdiction because in this case CPC will not apply, and in this case section 16 to 21 will not 20 will not apply, and only Mumbai court will have jurisdiction because arbitration seat is in Mumbai. So in this case, any petition pertaining to arbitration would be filed in Mumbai courts only. Clear? This is because the seat was in Mumbai. Otherwise, section 16 to 21 would have applicable. 20 would have been applicable. Clear?
Yes. There is one participant, Ayush, and he wanted to ask question directly. So may I unmute him?
At this, don't unmute him now. Okay. We can take up the questions later, but you can write it in the chat.
Yes, please write.
Ayush, you can write it in the chat.
Okay. Sir, we have one question from Sanjeev. I guess this question is regarding the last thing. He's saying, but the contract is entered into before the cause of action, something like that. If you can see in the Q&A tab.
Wait a sec. Sanjeev, but the contract is entered into before the cause of action. Which contract in this case? I'm not getting you, Sanjeev. Can you elaborate a little?
I guess this question is
cause of action starts when the contract is entered. The moment you enter into the contract, cause of action तभी शुरू हो जाता है. हाँ, partly तब start होता है. When you execute the contract, वो part cause of action है. I'll proceed.
Yes.
Now let us understand the meaning of actually and voluntary residing. ये words use किए थे हमने वहाँ पर. So a defendant must reside in real sense, and he should not be a mere visitor to that place. So दो चीजें हमें देखनी होगी. पहले तो उसने substantial time spend किया है उस जगह पर, and he has the animus, which is the intention to reside in this place. And सबसे important बात है कि जो person residing है, he must be voluntarily residing in that place. meaning that if a person is in jail, he is not voluntarily there. So that won't come under actually and voluntarily residing. And personally works for gain. A person must be physically and mentally working for the purpose of remuneration. अगर charity के लिए काम कर रहा है, then he is not personally working for gain. And carries on the business, he must he must be engaged in a commercial transaction, okay, which involves profit. Now, any questions so that we can move on to section 16, which is another interesting part. And the contract was entered before the movement of good. In which case are you talking about? The data wind case?
I guess the trading one, regarding the Tamil Nadu or the Mumbai jurisdiction where there was a dispute, right? So I guess this question was related to that question.
Okay. In this case, the contract was entered into before. No, see, this is a roadways company. The contract was entered for movement of goods and storing also. Yeah, contract was entered well before the movement of, yes. No, see, cause of action will be both. The entering of the contract, the entering of the contract gives them a right to sue them. No? Had they not entered into the contract, they wouldn't have got the right to sue them. So that is the reason even entering of contract itself is the cause of action. So cause of action not only means damaging of goods, but also the right. See, cause of action involves two parts: the right and the violation of the said right. In this case, the right is created by a contract which was entered, and by the fact that they had given them goods at their subordinate office. There is when their right is created to file a suit. And the violation of their right was when the goods were damaged. So both the places have cause of action. Clear?
Okay. We have another question from Realme C2, and that attendee is asking, what do you mean by animus?
Animus means intention.
Yes, and another question is from Shruti Singh. She's asking, like, what determines whether the time is enough? What about the nomads?
Differs from that differs from case to case. That is upon the court to decide that the time is enough. And in the cases of nomads, yes, that is an interesting question. In that case, you'll have to see whether they have the animus to reside on a particular place. If they have, then obviously you can file their case there itself.
Right. Okay.
I'll proceed.
Yes, please.
Now, section 16. Section 16 talks about immovable property. Section 16 says that in the cases of immovable property, you can file the suit where the immovable property is actually situated. So these are the few cases wherein you can file the suit where the immovable property is situated. The first case is, it starts with subject to the pecuniary and other limitations prescribed by any law. Suits for the recovery of immovable property with or without rents or profit, for the partition of immovable property, for foreclosure, sale, redemption in the case of mortgage or charge upon the immovable property, or the determination of any other right to or interest in any immovable property. Now, this is an important point. I'll explain this later. For compensation of wrong to immovable property, for the recovery of movable property actually under distraint or attachment, shall be instituted in the court within the local limit of whose jurisdiction the property is situated. So it says that basically in these cases, you can file a suit where the immovable property is situated. Now see, I understand the word recovery of immovable property. Okay. I understand the word partition. In the cases of partition where the immovable property is situated, that is also fair enough. I understand the cases relating to mortgage, which is sale, redemption, or foreclosure. But what is the meaning of determination of any other right? Now this is a residuary provision. It says that any other right involving immovable property. So any guesses, what are the other rights which involve immovable property other than these?
Lease from Maithili Jha.
Huh. What is it? Lease.
Lease, yes.
Yes, yes, correct. And
VG Shivaraman is saying land acquisition.
land acquisition. Wait a sec. Land acquisition, but that won't fall under the purview of CPC, sir. Anything else? Okay, wait.
Partition, is it partition from Jagannath?
Partition
Partition.
has been already provided in B clause, na? Partition of immovable property. So they wouldn't mean partition. Now they mean these rights. First is easementary right, lease and license. So in easementary right, you will file the case where the suit is, where the property is situated. In lease and license also, you'll file the case where the immovable property is situated. Even in the specific performance of the immovable property. For example, you are to file a case for immovable property on the basis of a contract. So even the specific performance of an immovable property, you will have to file a case where immovable property is situated. Even for attachment of the property, where the immovable property is situated. Even for eviction, where the immovable property is situated. For lien, where the immovable property is situated. For life state, where the immovable property is situated. Clear? Is this clear?
Yes.
Now there is a small hinge to this. Okay. Now there is a small hinge to this section, which is the proviso. Now proviso says when there is a case of personal obedience with respect to when a relief can be obtained through personal obedience, then you can file a suit even where the defendant is residing, personally working for gain, or carries on the business. Now the question is, this proviso basically carves an exception to the main provision. It says that in the cases of personal obedience, you can file the suit even where the defendant resides, or personally works for gain, or carries on the business. Now, what does the word personal obedience means? Basically, personal obedience means when a decree can be executed by making the judgment debtor or the defendant, any person, when a decree can be executed by making the judgment debtor personally liable, then it will be a case of personal obedience. Meaning कि आप डिक्री ले रहे हो और वो डिक्री में या तो जजमेंट डेटर अरेस्ट हो रहा है या उसकी प्रॉपर्टी अटैच हो रही है अदर देन द प्रॉपर्टी ऑफ द सूट. सो वो केस हो जाएगा पर्सनल ओबीडियंस का केस. उस केस में यू कैन फाइल अ सूट अगेंस्ट द डिफेंडेंट इवन वेयर ही मे बी फाउंड. क्लियर है?
Yes. Any questions, attendees, if you have?
Now I'll ask a question. You guys have to answer. Now this is a tricky one. I want your full attention. A and B entered into a contract in Delhi for construction of a house in Gurgaon. हाउस कहाँ कंस्ट्रक्ट हो रहा है? गुड़गांव में. कॉन्ट्रैक्ट कहाँ एंटर किया? दिल्ली में. कॉन्ट्रैक्ट हैड एन एक्सक्लूसिव जुरिस्डिक्शन क्लॉज ऑफ दिल्ली. उन्होंने बोला कि कोई भी सूट फाइल करोगे तो आप दिल्ली में ही फाइल करोगे. B committed a breach and A filed a suit in Delhi. 8 years later, B made an amendment of pleading. उसने amend किया pleading and he said that this court would not have jurisdiction. Delhi court has no jurisdiction. Now, I want you guys to answer these 3 questions. पहला तो है whether the question of jurisdiction can be raised at any time. दूसरा है whether Delhi court has no jurisdiction. तीसरा है whether exclusive jurisdiction clause is void. You guys can read it again.
First answer is no, as stated by Jagannath. Another, you can see the answers, replies, right?
Yeah, I'm seeing. Maithili says yes, as it is a question of law, can be raised at any time. Okay. Kajal says Delhi can have jurisdiction. Jagannath says no, Delhi has no jurisdiction. Okay. Delhi has jurisdiction, Shruti says. Dhanashri says yes to one. Kinjal says yes, no, it cannot be raised at any time, and Delhi can have jurisdiction. Maithili says that Delhi has no jurisdiction. Should I kill the suspense for you guys?
Yes, please.
Or you guys want to answer it? Okay, I'll read Sushil Shankar's. No, at the first instance. Okay, and Delhi has jurisdiction in the cases of immovable property. Okay, exclusive is superfluous. Superfluous. Okay.
Superfluous.
Any other? AA says no to one, yes to second. Whether has no jurisdiction. So you are saying that it has no jurisdiction. Exclusive okay when both the parties agreed. Okay, fine. I'll proceed.
Yes, please.
I'll kill the suspense. See, jurisdiction is a question of law. It can be raised at any time, even in the cases of appeal. The objection of jurisdiction can be raised at any time if they affect the merits of the case. This is the first thing, merits of the case. Okay. Secondly, yes, Delhi court has no jurisdiction. Why would it? The property is situated in Gurgaon. Delhi court का तो बनता ही नहीं है jurisdiction. And because Delhi court has no jurisdiction, they have conferred jurisdiction upon the court which has no jurisdiction. So ultimately, the exclusive jurisdiction clause is void. 23 or 28 में. Clear?
Regarding, I believe many of attendees would having the doubt regarding the first thing that we can raise the jurisdiction objection any time.
Yeah.
But we have all heard this that at first instance we have to raise the jurisdiction, right?
No, they are correct. They are correct. Absolutely correct. Section 21 tells you to raise the objection in the first instance, but the thing is that section 21 is a matter of procedure, and procedure is a handmaid of justice. And if justice requires that, it is not mandatory, rather it is directory. If the case affects the merits of the case, then in that case, the objection may be raised later on. It doesn't matter.
All right. Regarding your
but the contract, Dhanashri says that the contract, how it does not have. Read section 16 again. Wait. I'll explain this with section 16. Section 16 says that in the cases of immovable property, the jurisdiction will be where the immovable property is situated. It doesn't matter where the contract was entered. Since the property was situated in Gurgaon, the court in Gurgaon will have jurisdiction.
Right.
Yep. Yes, Kajal is right. Third parties can't out the jurisdiction of their they cannot confer jurisdiction on any court. Third question.
Third question's answer.
It's void, no? Exclusive jurisdiction is void because it's in restraint of legal proceeding and it's violative of public policy. Clear?
Yes.
You guys can ask questions on this one. This is a very crucial point, and this is what will make your understanding of CPC better. I'm happy to resolve all the queries. Should I proceed?
Yes. As of now, we do not have.
Okay, fine.
Yes. Kinjal is asking. She didn't get that why Delhi doesn't have jurisdiction.
Okay. Fair enough. See, See what section 16 says, that in the cases of immovable property, in these cases involving immovable property, for example, you are going for recovery of immovable property. For example, you are going for partition of movable property, immovable property, for you are going for mortgage of immovable property, or determination of any other right of immovable property, or any wrong committed to immovable property. In such cases, the jurisdiction will be with the court where the immovable property is situated, not in any other court. जहां पर वो immovable property situated है, वहीं पर आपको केस फाइल करना है, किसी और जगह नहीं. Now, in this case, interestingly, the suit was for specific performance of immovable property. Specific performance for construction करके भाई मुझे दे. बिल्डर था ना, they wanted the property back, DLF से, कि भाई कंस्ट्रक्ट करके मुझे दे. सो बट जो कंस्ट्रक्शन था, जो प्रॉपर्टी थी, वो सिचुएटेड थी गुड़गांव में. कॉन्ट्रैक्ट वाज एंटर्ड इन दिल्ली. सेक्शन 16 आपको क्या बोलता है कि जुरिस्डिक्शन उसी कोर्ट में होगा जहां पर, हाँ, तो इस जब एक्चुअली एक्सप्रेसली सेक्शन है तो उस केस में सेक्शन 20 नहीं अप्लाई करेगा, विच इज अ रेसिड्यूरी सेक्शन. सेक्शन 20 तब अप्लाई करेगा जब सेक्शन 16 ना अप्लाई करे. क्लियर?
Right. One question we are getting from AA. So we have read about the exclusive jurisdiction. So he is asking about if two courts have jurisdiction, so parties can agree on either court and exclude the other one.
Yes, that you can do. That you can do. That you can do, but you cannot give jurisdiction to a court which does not have jurisdiction at all.
Okay.
आप किसी उस कोर्ट को jurisdiction नहीं दे सकते जिसके पास है ही नहीं. आप किसी कोर्ट को एक्सक्लूड कर सकते हो. If two courts have jurisdiction, you can exclude one. But किसी कोर्ट के पास jurisdiction ही नहीं है, आप कैसे दे दो उसे? You are not parliament. You are not state government or something. You are only parties to a contract. So you can only exclude.
Understood, sir.
Clear?
Yes, sir.
Now, section 17. Section 17 provides that if an immovable property is situated in two different courts, तो दोनों कोर्ट के पास jurisdiction होगी. If an immovable property is situated in two courts, both the courts will have jurisdiction. And you can file a suit in any of those courts. Clear? This is basic. And now section 18. This is the most interesting part. See, what if the jurisdiction of a court is uncertain? Then what happens? The court will record a statement. And statement record करने के बाद it will proceed to entertain. And उस केस में same effect होगा जैसे उसके पास jurisdiction थी. Clear? Now what if the court does not record in statement? तो क्या adverse effect होगा? तो adverse effect ये होगा कि you can raise an objection before the appellate or revisional court. And you will have to prove that there are no reasonable grounds of uncertainty and there is consequent failure of justice. ये दोनों प्रूफ करने के बाद ही आप डिक्री सेट असाइड कर सकते हो, ऐसे नहीं. ठीक है. नाउ द क्वेश्चन इज, कभी आपने देखा है किसी कोर्ट की जुरिस्डिक्शन अनसर्टन हो? एटलीस्ट वेयर आई रिसाइड इन मुंबई, एवरी कोर्ट जुरिस्डिक्शन इज सर्टन. मतलब आपको पता है कि हद कहाँ तक है. मतलब in our place, the court civil jurisdiction, the territorial jurisdiction or civil jurisdiction is divided on the basis of police station. For example, यहाँ से लेकर ये police station तक, this and this court will have jurisdiction. And I'm sure in most of the places that would have been the practice. Now तो ऐसे में तो uncertain हो ही नहीं सकती jurisdiction. So what will be the case wherein this section will be applicable? So there is this interesting case in which this section will be applicable. For example, A wants to file a partition suit. Now, mind you, partition suit वहीं file होता है जहां पर property situated है, not in any other place. A wants to file a partition suit. अब A को लगता है कि joint Hindu family में दो घर हैं. एक है उसका बैंगलोर में और एक मुंबई में. पर मुंबई वाले घर के लिए वो श्योर नहीं है. उसे लगता है कि वो मुंबई वाला घर उसके पापा का पर्सनल घर है and joint Hindu family का घर नहीं है. But still he takes a chance and he files a suit in Mumbai. Now in this case, the jurisdiction of Mumbai court is uncertain. क्या पता वो जो पप्पा का घर है वो उनका पर्सनल घर हो और जॉइंट फैमिली ना हो, तो इस केस में कोर्ट रिकॉर्ड करेगा स्टेटमेंट, ठीक है, एंड इट विल प्रोसीड, record statement of uncertainty and it will proceed. Clear?
Right. Understood.
Now, last section. Now, this is an interesting section और बहुत basic है. Where a suit is for compensation of wrong done to a person or to immovable property if the wrong was done within the local limits of the jurisdiction of one court and the defendant resides and carries on or personally works for gain within the local limits of another court, the suit may be instituted at the option of the plaintiff in either of the said court. Meaning कि for example wrong commit हुआ दिल्ली में and defendant is residing in Mumbai, you can file the case in both the places, जहाँ पर wrong commit हुआ है और जहाँ पर defendant reside करता है. Simple. Any doubts so far?
We have no questions as of now.
Okay. Okay. Now, do you guys want me to continue or should I stop here? Because the next part will get a little lengthier, the objection. I can cover it in next section, next session also. It won't be a problem for me. But it's up to you guys.
Yes, participants, you can let us know if you wanted to. Murthy saying, yeah, please continue. Anybody else? Majority will win, of course.
Okay.
Yeah, we are getting a lot of, yeah, please continue.
Okay, okay. Okay. Objections. Now see, you can raise objections of two things basically. One is the territorial jurisdiction, which is the place of suing, and the other is the pecuniary limit, which is the pecuniary jurisdiction. Clear? Now in both the cases, you will have to raise the objection in the court of first instance, which is the trial court, and at the earliest possible opportunity. And in all cases, before the issues are settled at. And you will have to prove that there has been a consequent failure of justice. If you do not prove, then nothing will happen. Clear? So two conditions are there. One, court of first instance में आपको raise करना है और earliest possible opportunity में raise करना है, if possible before the settlement of issues. And दूसरा आपको prove करना है कि consequent failure of justice है. Same here. Clear? Now this is for execution. 21 clause 3. 21 subsection 3 provides that in cases of execution क्या होगा? Even in the cases of execution, आप executing court में earliest possible opportunity में objection raise करोगे और consequent failure of justice भी prove करोगे. Now the question is whether a delayed objection will not be considered at all. Guys, you can answer. Whether delayed objection will not be considered at all.
Will be considered. So, yeah.
It should be considered. Kajal says no. No.
Anybody else? Reasonable justification.
Reasonable delay is considered. It can be considered. Ashna says it will be considered. Yes, it will be considered. Okay. You guys are correct. Yes, it will be considered because you cannot read procedural law rigidly. And the time provided in section 21 is a caution. It is not a rule. Okay? If the objections have delayed and not raised at all, the general rule is the court will not set aside the decree. But if the delay is bona fide, if the plaintiff if any person who is delaying can explain the delay, then the court will tilt towards the appellant. Okay? Now, see, now the thing is, section 21 provides that no objection, when the objections are to be raised, and there will be you will have to prove consequent failure of justice. While on the other hand, section 99 says that no decree shall be reversed or substantially varied, nor shall any case be remanded in appeal on account of any misjoinder or non-joinder of parties or cause of action or error, defect, irregularity in any proceedings not affecting the merits of the case. Now the interesting part is, अब दोनों में क्या कॉन्फ्लिक्ट हो रहा है? ये बोल रहा है कि सेट असाइड हो सकता है अगर आपने ये प्रूफ कर दिया. ये बोल रहा है कि वेट अ सेक, ये बोल रहा है कि नो डिक्री शैल बी रिवर्स्ड और सब्सटैंशियली वैलिड. ठीक है, अनलेस द मेरिट्स ऑफ द केस आर नॉट इफेक्टेड. तो क्या कॉन्फ्लिक्ट है दोनों में? वेदर देयर इज अ कॉन्फ्लिक्ट?
Matley says no.
Yes, no, there is no conflict between the both, because it has been held in Kiran Singh versus Chaman Paswan that section 99 explicit करता है कि कोई इरेगुलरिटी की वजह से कोई डिक्री आप सेट असाइड नहीं कर सकते. आपको ये प्रूफ करना होगा कि मेरिट्स ऑफ द केस इफेक्ट हुए हैं. ठीक है, एंड section 921 provides for conditions, two conditions. So these both, section 99 and 21, they both are in connivance. Section 21 provides for conditions कि पहले तो आपको अर्लीस्ट पॉसिबल अपॉर्चुनिटी में करना पड़ेगा एंड कॉन्सिक्वेंट फेलियर ऑफ जस्टिस होना चाहिए. और सेक्शन 99 प्रोवाइड्स कब कब आप सेट असाइड कर सकते हो डिक्री. तो सेक्शन 99 प्रोवाइड्स फॉर पावर and section 21 provides only for conditions. So therefore they both are not in conflict with each other. Rather they both are complementary provisions. Clear? That is it. You guys can ask questions. This is the right time to ask all the questions.
Ayush, if you are still in the session, you can ask your question. I can unmute you.
Okay, there are.
If you wanted to ask question, Ayush, you can unmute yourself. And if anybody else, yes.
Hello. Yes, am I audible?
Yes, Ayush, you are.
Yeah, my question was in relation to that ruling of the Supreme Court, which you talked about.
Arbitration.
The Justice Nariman ruling.
Yeah. Say.
As far as I remember, the facts of the case, where either of the party, while executing a contract, laid down that the state would be Bombay, right?
Correct.
But the venue was not decided.
No, the seat was decided. It's in the judgment.
Seat was decided, but venue and seat has a difference.
Different meaning, yeah. Seat is where you take all the evidences, and venue is when actually there is a difference between venue and seat, and the difference, I would say, venue is where you decide to conduct, where you decide your decree to be passed or your arbitration award to be passed.
Okay.
While seat is where you take all the evidences. So the court held that since the seat was Mumbai, so they must have wanted, their intention was, and the exclusive jurisdiction clause also said that the court will be subject to Mumbai itself. So they must be want to be.
So precisely what my question is, you said about the exclusive jurisdiction as per the CPC.
Correct.
And the contradiction of the CPC exclusive jurisdiction and the Arbitration and Conciliation Act jurisdiction.
Correct.
So my question to you is that does CPC, the statute or the code, the rulings can overrule the IBC or Arbitration Conciliation Act?
No.
How come?
CPC is a general provision. Arbitration is a special provision. CPC cannot override arbitration anytime.
But you said in the Justice Nariman judgment, he himself ruled that if it is laid down in the contract.
He did not rule that. He said that what he said that, see, in this case, In fact, he said what I am saying. He said that in this case, since it is a case of arbitration, section 16 to 20 of CPC will not apply.
Hmm.
So in this case, he said that the Arbitration Act or the principles envisaged in arbitration law will prevail over the civil procedure.
Will
Prevail.
prevail over the civil procedure, na?
Yeah.
See, if any party to the contract wants to avail the provisions of Arbitration and Conciliation Act, they just have to insert a clause, nothing else.
Yeah,
Am I right or wrong?
absolutely.
Yeah. So this is in contradiction with the CPC exclusive jurisdiction laws, aren't they?
No, it is not. It is in fact in connivance with that. In fact,
See, for
both.
example, I'll give you an example.
I'll give you an
If
example. I think I can resolve your issue.
yeah.
It's very simple. It's very simple. See, now my interpretation of the judgment is something like this. Now when I say I am conducting an arbitration proceeding
Hmm.
in Mumbai,
Hmm.
am I not creating cause of action in Mumbai?
Yeah, definitely.
So
Implied cause of action is there.
it will fall under 20 clause C. So they both are in connivance.
Hmm.
It does not they both are not in contradiction, but if they are in contradiction, if at all, in that case Arbitration Act will prevail because it is a special provision.
It is special law, no doubt.
Yeah, and special law anytime will prevail over the general law.
Hmm. Okay, thank you.
No problem.
Thank you, Ayush. If anybody has any doubt, if they don't have, please share your feedback with us. And we are getting one question from AA. Yes. So in case of uncertain jurisdiction, after the judgment decree of the case of the courts get to know that they don't have jurisdiction, then what happens?
Wait a sec. In uncertain jurisdiction, after the judgment of the case, if the courts get to know that they don't have jurisdiction, in that case, what happens? See, if the court gets to know, then the court cannot do anything. You'll have to you'll have to raise an objection before the court, and you will also have to prove that there was no uncertainty. And if the courts then come to know, then it is fine, because it is provided in that section itself that the courts will be deemed to have jurisdiction. So we have created a legal fiction saying that even though the courts do not have jurisdiction, but we'll deem that they have jurisdiction because they have recorded the statement. No?
Right, understood. We have another question from Kajal, and this question is, if you can briefly tell us what is preponderance of probability, which is there on the plaintiff in the civil suits.
Preponderance of probabilities. Preponderance of probabilities means you do not have to discard all the evidences of the defendant. You'll only have to prove more than the defendant, a tilt more than the defendant.
Right. Okay. So anybody has still questions? Otherwise, we'll sign off. And those who have missed the session, definitely we'll upload this session on the YouTube itself. After 4 or 5 days, it will get uploaded. So from there, you can, take a screenshot of slides and yes, and we have received such a good feedback. And of course, one thing which Shruti Singh said that CPC was never been such a interesting subject. So it was indeed a very
Thank
insightful
you.
session.
Thank you. Always pleasure.
So yes, so now I'll sign off, and thank you, sir, for sharing such a wonderful insights and making it more practical for students. So yeah. All right, so now I'll sign off, and thank you again. Thank you, participants, for joining, and please join us for another session. We'll be coming up with some other interesting, webinars. So stay tuned with us till the time. Stay home, stay safe. Now I'll sign off. Yeah, thank you.